Chargebacks are related to contributions, which I spoke about earlier. So let's just set the frame or set the table on what a chargeback is or might be. Let's say I move in this weekend to your complex. It's full of snow, it's cold. I back my moving truck up to the door, and it turns out in doing so, I damaged, or whoever was driving the truck, trying to move my stuff in, damaged the landscaping. Let's say it turns out to be $1,400. The way the law is written right now, the way the courts have interpreted it, if we have the right bylaws, and the board does an investigation and can prove it's me, you can pass a resolution that says, charge that $1,400 as if it was a special assessment against me. We know that when that happens, because it's now a contribution, if I don't pay it, we can file a caveat, we can foreclose. We get priority over the bank, right? So one of the proposed changes, which was last year, a year and a half ago was when we really got organized on this. In the Amendment Act, it proposed to say expressly that chargebacks cannot be a contribution. Meaning if that was to have been proclaimed, that you would have to chase me in small claims court. Are you going to do that for $1,400? Maybe, maybe not. But if you don't, who is now financially responsible for my breach? Everybody else, right? So what we did is we said, no, this doesn't work. This doesn't make any sense for condos because you're making compliant owners financially responsible for the breaches of others. So people wrote letters, people sent postcards, CCI was active on this, and the government did not proclaim that section, meaning that section's not in force. Next week, we're going to have a meeting about it. So I'm going to do a quick show of hands vote. How many people here believe the chargeback, that $1,400, if the board has the bylaws and the board investigates and the board passes a resolution, should be allowed to be a contribution? Hands up. Can I get a picture of that?
Just keep your hands up. Beverly wants to take a shot.
I'm going to count the hands. No, we're not going to count the hands.
All right. Thank you very much.
Because that's what we thought. And that's been every single time we ask that question, the response is the same. So now that we sort of set the table on chargebacks, let's jump into a little bit more deal. Just go back a slide. So those people who did send a postcard or wrote a letter, congratulations, you made a difference in the law. So that effort you put in was instrumental in causing change. So congratulations for doing that. Jumping forward. So if we're looking at, oh, I have a different page here. Oh, there we go. I had it turned backwards, my fault. What we want to do is in the meantime, is let's look at some best practice. And I think if as an industry we drive towards this best practice, we're, again, in a strong position to be fair and to cause some positive change. And what that is let's make sure we have the bylaw language. Let's make sure the owners agreed with each other that if I breach the bylaws or through my negligence I cause a loss that wasn't budgeted for or an expense, that I'm responsible for it. Then when we have an item, we have to investigate it. Just because we don't like Charlie Brown and it happened towards his end of the complex or his end of the building, oh, it's at Charlie Brown. And even if we're really sure it was Charlie Brown, but we don't have proof on a balance of probabilities, we can't guess. We can't do that because when we do that, you're fundamentally affecting someone's property rights. Like you could potentially foreclose over this. You can't be mistaken as a board level. You have to do the investigation and you have to make sure there's legitimate evidence because as a board member, you are acting reasonably and prudently. And a reasonable and prudent person would have evidence before deciding to charge someone something that might cost them a fair bit. Then you need to pass a resolution. I like the idea of telling the owner, saying, hey, you drove on the grass, we saw you do it, we knew you do it, you caused the landscaping damage, here's our quotes, we've spent this money, we're going to charge it back to you, we'll give you 2 weeks, we'll give you 30 days to pay it. Otherwise it goes on your ledger and eventually we'll have to pay it or we'll notify the bank or start foreclosing. I would suggest you implement the same process for every chargeback, whether it's a locksmith, NSF fee, whether it's an insurance deductible, whether it's hoarders, someone who's not responding to the bed bug notice and the bed bug person had to come 2 or 3 times, that extra cost. That way, when you do it the same for everybody, it becomes routine. You don't accidentally miss a step, as well as you protect yourself from the allegations that, well, you're picking on me. You're only doing this against me. And this way, you're able to insulate that. It's like, no, we treat everybody the same. Next slide. So one of the changes that was in there that was supposed to have come in effect as of July 1st that's changed is around caveat costs. So what the rule, or what the legislation now says is the cost for preparing and registering and discharging the caveat at land titles cannot be more than the amount you're trying to collect. So if you're trying to collect $400, you can't charge $500 in the preparation, registering, and discharge. Now, enforcement on the caveat, the court proceeding is separate, but the registration, preparation, and discharge. Where the change came in is the wording had said that you could charge legal fees. And nobody had asked for that, because what it did is it, I think, accidentally cut out condominium managers who place their own caveats and have their own process and fee. So that was actually fixed. So now it says legal and other professionals. So the other professionals will allow a condominium manager who does their own caveats to put their own charge on that way. It doesn't all have to come in. The land titles registration costs can be on top of that. Be aware those costs for land titles went up as of January 1st. One final thing I'll say on this slide is your caveat costs, if you're doing them yourself, you're sending them to legal, they still have to be reasonable. So even if the caveat you're collecting is $20,000, you can't be jumping your caveat cost to $1,000, $1,200. That's not reasonable. And I think a few bad apples may spoil a bunch for everybody. So just everybody reconsider what your costs are in terms of placing that. Next slide. The regulation does not address the cost for enforcing the caveat. This is something that we need to address, and this is another chargeback issue, is if the corporation has to hire a lawyer to go in and collect that chargeback or collect that unpaid special assessment or unpaid condo fees, most bylaws say the owner who's in collections has to pay the legal fees. Similar to what your mortgage on your bank says. If they have to take steps to collect, you pay the bank's lawyer. There's an issue in the courts that we have to resolve because the courts in southern Alberta, in Calgary, say those legal fees are allowed to be added as a contribution, meaning they have priority. The courts in Edmonton say no, meaning you get your special levy, you get your chargeback, you get your monthly condo fees, but the collection costs get paid after the mortgage. So we need that resolved one way or the other, and we need it resolved. It's a fundamental fairness issue that if the condo corporation's lawyer and the bank's lawyer are fighting over whether the legal fees have priority or not, the end result is the owner ends up paying more to both, right? So we're asking the government to give us clarity one way or the other so that we can just move on and keep some of these things out of court. That's it for chargebacks and caveats.